My name is Brandon Zhang. I represent the appellant, Mr. Antonio Fortuna. I will speak for 20 minutes on all four issues, and then the respondents will speak. Ramesh, just do you want to come on this side here?
Yeah, sure.
Good morning, members of the panel. My name is Seah, Ramesh, Kanna, and together with my co-counsel, Mr. Austin Seah, we appear on behalf of the respondent, the Federation Internationale de Football Association, FIFA. I'll be addressing the first two issues for the first 10 minutes, namely whether Mr. Fortuna's statement of appeal is admissible, and thereafter whether his refusal to surrender his mobile phone to the respondent was lawful, together with the potential legal consequences that may arise. And Mr. Seah would address the panel on the remaining two issues for 10 minutes. We respectfully reserve 1 minute for our rebuttal.
Sorry, so just to clarify, we will only have one appellant speaker today?
Yes, correct. My co-counsel, Mark Maxwell, Peter, is not available to make the session today.
Okay.
Good evening, Madam President and Ms. Arbitrator. My name is Brandon Zhang for the appellant, Mr. Antonio Fortuna. The appellant has devoted his entire life to the game of football. A late bloomer by reputation, he trained relentlessly to earn the honor of representing Iridonia in its 2026 FIFA World Cup qualifier, a moment of immense national pride. He stands before this tribunal seeking nothing but the opportunity to defend himself. I now will make submissions on four issues. First, that the statement of appeal is admissible. And second, my client has been violated of his fundamental rights to a fair trial. Third, that the anonymous witness statements and evidence is inadmissible. And lastly, that there has been no violation of match fixing under Article 20 of the FIFA Disciplinary Code. I now turn to the first submission. It is our submission that the statement of appeal is admissible for two reasons. First, the challenge decision with grounds is the day of receipt, and therefore it has been filed within the 21-day time limit. And second, the appeal was only late due to an IT cyber attack, which my client had no control over. And we have also submitted Exhibit 8 to prove that it was filed within the deadline timeframe. Turning to the first argument, the CAS panel has recognized that the starting day of the 21-day timeline is the day where the parties receive the decision with full grounds. In the 2016 CAS decision of Ivan Bellado Palacios versus PFC CSKA Sofia, at paragraph 75, the panel held that the appeal was admissible and that the starting date was the day when the party received decision with full grounds. In the present case, at paragraph 26 of page 5, the challenge decision was sent to the parties with grounds on 2nd April, and below at paragraph 27 of the record, the appellant had filed the statement of appeal and paid a 1,000 Swiss franc fee. And therefore, we submit that the statement of appeal has been filed on time, pursuant to the 21-day time limit set out under Article 50, subsection 1 of the FDC. And turning to the second argument, Madam President and Ms. Arbitrator, this appeal was only late due to an IT cyber attack that my client had no control over. And there is a case which the panel cured a late statement of appeal. In the 2013 CAS decision of AC Siena SPA versus Club Desportivo Nacional at paragraph 39, the statement of appeal was filed late, one day. However, the panel held that it was admissible when the appellant produced evidence in the form of a shipment waybill to prove that a carrier company had picked up the statement of appeal and held that it was admissible. And that statement was also filed on the very last day. Similarly, in our case, this is precisely the same situation, and therefore we submit that the statement of appeal is admissible. I now turn to the second submission. We submit that my client's refusal of the mobile phone was lawful for two reasons. First, Article 6, subsection 1 of the ECHR, the European Court of Human Rights Convention, is applicable. And second, we submit that the respondent, FIFA, violated my client's right to not self-incriminate himself under Section 6, subsection 1, and violated my client's right to privacy under Article 8 of the Convention. On the first argument, we submit that my client has a right to not self-incriminate under Article 6 for two reasons. One, my client's right to occupation is at stake, and here he's been sanctioned to 5 years with an additional $100,000 Swiss franc fine. And second, the arbitration clause, the duty to cooperate under Article 12 of the FDC is compulsory, and therefore had to afford the safeguards by Article 6 of the Convention.
Sorry, could I just clarify on that? So you are relying on the fact that your client has a right to not self-incriminate under Article 6, is that right?
Yes, Madam President.
But wouldn't the implication of that be that you're admitting he is in some way guilty and that's why he needs this right against self-incrimination? Because if your client is completely innocent, I mean, what is he going to self-incriminate himself for?
Thank you, Madam President. My client, on the facts, if I may direct Madam President and Ms. Arbitrator's attention to page 3, paragraph 13 of the record. Is the panel with me?
Yep.
Here I'll read. I state here, the Iridonian Public Prosecutor's Office launched an investigation into the appellant and his father for sports manipulation. So concurrently, there are criminal investigations against my client as well as his father's. And we submit that there's nothing on the phone to incriminate my client. However, there is evidence and there are allegations against my client's father, and my client is only refusing to submit his mobile phone under the right not to self-incriminate himself and his father, because his father is at risk and there is concurrent proceedings, and the evidence that we submit to the FIFA disciplinary committee could be very well shared with the Iridonian public prosecutors.
So
I'm sorry, but
sorry, please continue first.
no, Rachel, it's okay, go first.
Is FIFA obligated to pass such any findings of their investigation to the Iridonian Public Prosecutor's Office?
And if I could add on to that question, you said that the part of the reason why he has this right or he wants to rely on this right is because it may implicate his father, right? Because there's allegations against his father. But if I'm hearing you correctly, this is a right against self-incrimination. So how does this extend to his father?
It is also applies under self-incrimination because he is also under criminal investigation.
Yes, so that only protects himself, right? He can't rely on allegations against his father to invoke this right. which means the only thing that we are relying on this right for right now is the fact that it may potentially implicate him. But that goes back to the question, right? Because if he is truly innocent, regardless of whether or not his father is innocent or not, if he is truly innocent himself, why does he need this right?
Thank you, Madam President. I will make a further argument that the European Court of Human Rights has ruled that compulsory evidence, the acquiring of compulsory evidence is a violation of the right to privacy and the right not to self-incriminate. For example, in the 1993 European Court of Human Rights case, Funke versus France, and the 2001 European Court of Human Rights case, JV versus Switzerland, the court held in both those cases that when the tax authorities requested the applicant on separate occasions to produce evidence, that this was a violation under Article 6 and Article 8 of the convention. And therefore, in the present case, we argue that notwithstanding what is on the phone, that this would still be a violation under Article 6 and 8. And this CAS panel, in the case of 2013, Atomos versus FIFA, at paragraph 66, I quote, "The panel is mindful that some guarantees afforded in relation to civil law proceedings by Article 6, subsection 1 of the ECHR are indirectly applicable, even before an arbitral tribunal." And the CAS panel in the 2017 decision of Jerome Valk versus FIFA at paragraph 266 stated, "Where there are concurrent disciplinary and criminal proceedings, the privilege against self-incrimination appears to be debatable." And on this point, I would like, in respect of the time, if there are no further questions, to move on to the third submission.
Sorry, I still have one clarification to make. You also mentioned that there was a duty to cooperate under Article 12, right? What exactly is, I mean, based on case law or interpretation of the FIFA disciplinary code, what is required? What is the standard that is required for athletes to cooperate with FIFA? Because they are also saying that he is not cooperating with them, right? So why is he not in violation of this duty to cooperate by not handing over his phone? I mean, they need it for the investigations, right? So yeah, could you explain on that?
Yes, Ms. Arbitrator. The duty to cooperate cannot be absolute. The compulsory requirement of handing over a mobile phone in today's modern age, we submit, is too intrusive. And the duty to cooperate is not absolute. In the 2018 European Court of Human Rights case, Mutu and Pechstein versus Switzerland, at paragraph 109 to 114, the panel held that where the athlete's right to occupation is at stake, that there is no duty to, that where there was a sanction, that this related to the civil head under Article 6, subsection 1. And therefore, the court in that case held that the arbitration clause, the duty to cooperate, was a compulsory arbitration clause, and therefore it had to afford the safeguard secured by Article 6. So in the present case, we argue that the athlete's occupation is at stake and falls under the civil head of Article 6.
Sorry, if I could press you a bit more on that. What exactly do you mean by the athlete's right to occupation, and how is that measured?
This relates to the compulsory arbitration clause, the duty to provide evidence, and the duty to not, and as well as the right not to self-incriminate.
But what does that have to do with occupation?
The right to occupation, therefore, where there's a right to the athlete's occupation, there's a right not to produce evidence to self-incriminate.
So how do we assess whether this evidence affects the self-incrimination, or how do we assess whether it affects the occupation?
Because the arbitration clause, the duty to cooperate, it was a compulsory arbitration clause. The court in Metru Pestine reasoned that the athlete had to compulsory accept this arbitration clause, and therefore held that, in essence, that the arbitration clause was not absolute. Apologies for the confusions earlier.
So you're saying that this arbitration clause is not actually compulsory because the athlete was, in a way, coerced to accept it.
Correct, because the reasoning from the Mutu Pestine case is that if the athlete didn't sign and agree to the clause, that she would have essentially no occupation, that she had to sign this contract, this arbitration clause, in order for her to practice her sport or not to practice and make a living. That was the reasoning from the court.
Yes, no, so I understand that you're making argument, correct me if I'm wrong, that the athlete was kind of forced to agree to this, otherwise they can't have their occupation, right? Like, because they can always just get rid of the player.
Yes.
But then wouldn't this be the case for almost every player? Are you then saying that every single arbitration clause that exists in the world of sport is now moot? And also, how would we get how could we differentiate between that? Do we have anything that even suggests that the athlete was under coercion? Because it seems like, at least on the facts, there's nothing to support that proposition that the athlete was forced into doing something or agreeing to something.
There is some cases where it was said that if the athlete had the opportunity to play in another organization, that it would render the clause to be effective. But in the present case, that my client is playing for FIFA, and this is a well-known organization in the World Cup qualifying games.
Okay.
Turning now, I'll begin now on the third submission. We submit that the evidence is not admissible for three reasons. First, past jurisprudence applies strict safeguards with respect to anonymous evidence. Second, these safeguards have not been satisfied. Both anonymous email and the anonymous witness statement. And third, even if the evidence is admitted, does not meet the comfortable satisfaction, and alternatively, if admitted, has very little evidentiary weight. In the 2019 CAS decision of Karamudin versus FIFA, at paragraph 129, the panel held that the use of protected witness is subject to the following conditions. First, necessity. Second, a risk of retaliation by the testifying party. And third, that the witnesses are questioned by the court itself, which must check their identities and the reliability of their statements. And fourth, that the witness must be cross-examined through an audio visual protection system. In our case, we submit that the evidence is inadmissible because the witness's identity has not been identified and the witness has not been cross-examined under the audio visual protection system. In the Paramudan case, at paragraph 188, the panel held that the screenshot messages carries no evidential weight, even if there's a name attached to it, because the appellant had failed to prove their authenticity. If I may now direct the panel's attention to the PDF, page 34. Here you will see Exhibit 3, and further 2 pages, you will see Exhibit 4. In these 2 exhibits, these are anonymous, and one of them has a name attached, and it is merely an allegation that the witness has reason to believe that the father received Bitcoin. And Exhibit 4 is inadmissible, even if it has a name attached to it, as it was held by CAS that there's no evidential weight. And therefore, we submit that the evidence is unreliable and carries no evidential weight. I now turn to the last submission. The respondent alleges my client of match fixing under Article 20 of the FDC. We submit that there is no. Sorry?
Could I clarify? Is your reason for saying that the evidence is inadmissible because it is anonymous, or because that they are unable to verify who is the one talking? Was that what you were saying?
Yes, Madam Arbitrator. First, it has to be verified and cross-examined by the court. So 2 reasons. The identity has not been verified through the audio protection system. And second, we have not had the opportunity to cross-examine the witness. And the last point is that FIFA had interviewed multiple players. However, only one player gave an interview, but refused to even participate in the audiovisual protection witness program.
But surely, I'm sorry, are there cases that have thrown out evidence on this point? And also, I mean, I would assume that such testimony can be quite sensitive, and maybe the athlete in question also does fear for his right to occupation and his own career. So how can we reconcile this need for verification
Yes.
while also protecting athletes who come forward?
Also adding on that, I think in paragraph 9 of the facts, it was FIFA who interviewed the supposed anonymous witness, right? So can we really say that his identity can't be verified, or that it's a unreliable source if FIFA themselves were the ones who collected the statement?
Madam Arbitrator, the CAS panel held under Lim 3 for anonymous evidence admitted that the court itself must verify. The respondent FIFA cannot simply conduct an interview and then claim that it's reliable. And second, I noticed, or rather, Madam President had asked, was there a case? And yes, in the Karamudin case, the panel held and rejected screenshot of messages and held that it carried no evidential weight because the identity was not verified. Now, Madam President and Ms. Arbitrator, if I may have just 1 minute to complete submission 4.
Yep, please go ahead.
We submit that the client is not guilty of match fixing for 3 reasons. First, the evidence does not meet the threshold of comfortable satisfaction. Second, the Genius report and the betting report does not itself constitute match fixing. And lastly, the performance analysis directly rebuts the allegations. In the 2021 CAS decision, Ofusu Apaya versus LFF, the panel held that the contents of the reports, the betting reports, in no way whatsoever attributed any considerable evidential value to the wrongdoings, and that the betting report itself cannot, without other evidence, link the appellant to match fixing. And if I may briefly point, or rather, in the present case, on PDF page 15, here, goals number 2 and 3 was said not to be of a performance error. And on the last point, or rather that in goal 3, it was Santiago who had an injury that led to the goal. And both the second and the third goal was not attributed to my client. And on the next page, it states at line 1 at the minute 82:43 that Paul attempted a diagonal ball backwards his own goal. And this goal was saved by Iridonia goalkeeper, my client, Mr. Fortuna. And here we have evidence that states that 2 of the goals were not due to my client's fault, and he in fact saved one of the goals. If there are no further questions, this concludes my submissions.
Just one question before you go. I noticed that your argument is premised on the fact that the report alone by itself cannot link the appellant to the match fixing allegations, right? But I mean, we also see that there's evidence of money being transferred, and these witness statements, if we allow them in, can be quite damning. So, what is your response to that?
Thank you, Ms. President. On the first point, Madam President had queried about the money. And here in the Exhibit 3 itself, it stated that I have reason to believe Mr. Luck Fortuna received 50,000 Dodge coins. This is not a fact, and this is just what he believes. And this anonymous email has not been verified. And on the and can I ask what the second query was?
On the witness statements, I guess the question is, if we look at the circumstance in totality, where we have allegations of money being transferred and also witness statements coming forward, on the assumption that we do let these in as admissible, it could be quite damaging to your client. So how would you respond to that?
Yes, Exhibit 5 is the Iridonian Public Prosecutor's press release. And here at the third paragraph, investigators confirm that Mr. Luck Fortuna has provided access to his Dogecoin wallet on his own free will. And therefore, if the father had nothing to hide, he would have refused this request. And moreover, in Exhibit 2, the witness statement clearly states, I heard Mr. Fortuna arguing with his father, saying, no, I cannot go along with whatever you're asking me to do. And therefore, 2 reasons. One, it's been taken out of context, so we don't know what the appellant's father asked him. And second, even if the appellant's father had asked him to engage in any match fixing activity, he clearly declined the request and refused to do so.
Okay, I'm so sorry, but I have 2 more questions if you don't mind.
Yes, of course, Madam President.
The first question is you referred to Exhibit 5, which is a prosecutor's statement, the public prosecutor's statement. Am I right?
Yes.
So I'm just wondering if there's any implication about how there are 2 concurrent investigations going on here, and whether there will be a clash between the 2 organizations since they are essentially investigating the 2 things. So, for example, what would happen if they come to different conclusions, or one chooses to admit the witness statement and one doesn't choose to admit the witness statement? And well, maybe you can answer that question first, and then I'll ask the second one.
Well, we say that my client's not had a right to defend himself properly. FIFA's appeal decision essentially violated his right to a fair trial under Article 6. And where this is ongoing criminal proceedings, this could be very unfair to my client. And information can be shared by the FIFA to the Ecuadorian public prosecutors, which may later affect those proceedings in regards to my client and my client's father. And on the second question,
the second question would be that the lower court decision does find your client guilty of the match fixing under Article 20, right? So shouldn't this be indicative of something?
with respect, we argue that the evidence is not admissible as it is hearsay evidence, double hearsay evidence. So anonymous
Sorry, I'm not talking about the anonymous witness evidence. I'm referring to the lower court judgment, which ruled in the respondent's favor. I'm wondering how much that indicates.
Well, we argue that the proceedings can also again be brought before the European Court of Human Rights, where they have held consistently in cases as the two I have mentioned, Fouquet versus France and JD versus Switzerland, that compulsory acquisition of evidence is a violation of the right not to self-incriminate and the right to privacy.
Okay. Rachel, anything further?
Thank you.
Thank you.
Before I begin, could I check if I'm audible?
Yep.
Just give us a moment. Apologies. Okay. Good evening, members of the panel. The case that confronts us today requires the panel to make a balancing exercise between procedural fairness and substantive fairness. Now, on this sliding scale between procedural and substantive fairness, where the panel stands has already been decided, set in stone by the CAST Code. However, in a limited number of exceptional cases, CAST panels have moved on this sliding scale to trade off procedural fairness for substantive fairness. And the opposing counsel argues that this is one such case. However, we beg to differ. And with this understanding, I make two submissions. Firstly, the statement of appeal is inadmissible. And secondly, the right against self-incrimination does not exist. Now, with regard to my first submission, I make it on two grounds. Firstly, this statement of appeal had not been delivered on time. And secondly, given that it was late, the deadline should not be reinstated. Now, we agree with the appellant that Article 50, subsection 1 of the FIFA statute is applicable to today's proceedings. And we also agree that the appellant has only needs to file the statement of appeal when he or she receives the full grounds of appeal, which makes the deadline for filing the statement of appeal 23rd April. However, when opposing counsel made their submission, what they have conveniently left out is that by operation of R31 of the CAST Code, specifically for electronic filings of the statement of appeal, the filing is only valid upon receipt of the electronic mail by the CAST Code office. That is, it is to be noted that it's receipt that would ensure a proper filing has been conducted, not a sending act. So in this case, even though opposing counsel has chosen to focus on the dates and the exact deadline, the fact that the statement of appeal was never received in the inbox of the sender shows that a filing has not been completed.
Counsel,
Now, this
how would
much is
reconcile this with the opposing counsel's case about I think how mail was shipped out and they had evidence that it was shipped out on like within the filing deadline, but it just didn't reach them in time. How does that reconcile with this case?
And also just adding on to that, I know that you are going by the argument that the rule is upon receipt, right? But in this case, can't we consider it an exceptional circumstance because, like the appellant explained, there was a cyber attack?
I will first answer, Madam President. So if I could refer Madam President to Exhibit 9 of the record on page 52 of the PDF document. Are members of the tribunal with me? So this is actually an explanation given by the IT team of the law firm that explains that the act of irregularity that they claim would not have allowed for the email to be sent out to the recipient's inbox because it was a technical error on their side, not on the side of the recipient. And to answer Madam Arbitrator's question, that would bring us to the second ground of this submission, which is whether this is an exceptional circumstance that would warrant a reinstatement of the deadline. And the answer to that is no, because there are two elements that have to be met for this to fall within such an exception. Firstly, the irregular act must not be of any fault of the sender. And secondly, the sender must have acted promptly. Now, this was seen in the 2024 CAS case of FC Football Club and Galatasaray AS. Now, the standard of no fault is exceptionally high and requires a demonstration of utmost diligence in the face of impediments. The appellant failed to demonstrate the necessary foresight and internal procedural safeguards required by this standard, particularly concerning the timely filing of the appeal. This is stated from reference to the fact that even after the IT team had responded that there could have been a particular technical issue, the email was not sent out immediately to CAS. They still waited after one working day to send it. And now we may think that, well, isn't a 2-day delay prompt? Well, promptness doesn't just depend on the time. However, it also depends on the whole contextual matrix of how they acted towards the issue. And in this particular case, the delay was not a single-handed event, but rather a pattern of disregard for procedural safeguards. This can be seen from the fact that the appeal brief was also sent late by the appellant. Moreover, beyond this limb, given the fact that there has to be no fault on the appellant, this element has also not been met, as established in the 2023 SFT case of B and FIFA. An impediment that appears early or during the running of an appeal period does not qualify as unforeseen if the legal representative fails to take precautionary measures, such as timely delegation. So in this particular case, the facts was that there was a severe health issue faced by the advocate, and therefore they could not send a particular document in. And the court ruled that, given the fact that they could have done it much earlier, this doesn't count as an exceptional case. Now, if we see the present case, they had attempted to send in a statement of appeal at 23:45 on the final day of the deadline. This would not count as an exceptional circumstance simply by the fact that it was not timely and it did not take into account of precautions. Now, I note my time. If members of the tribunal have no further questions, I will move on to my second issue. Opposing counsel's second issue stood on two grounds. Firstly, he argued that the right against self-incrimination would extend towards the appellant's father. And secondly, that a right to occupation would render the Article 20 of the arbitration clause irrelevant. Now, both these grounds of argument are misguided. Firstly, with regard to the right to self-incrimination, this is founded upon Article 6 of the ECHR. Now, whether Article 6 of the ECHR applies is in itself debatable, because following the 2017 CAS decision of Jerome Balke, at paragraph 263, The guarantees recognized in a criminal trial are inapplicable per se in a disciplinary proceeding before FIFA. And the reason for this is because an authority like FIFA does not have the same evidence finding measures or machinery that a state has access to. Therefore, although Article 6 is applicable by virtue of the fact that this panel is seated in Switzerland, its entirety is not applicable, and an exception should arguably be carved out for the right against self-incrimination. Nevertheless, even if members of the tribunal are insistent that Article 6 applies, we argue that the threshold to invoke the privilege against self-incrimination has not been met, because this particular threshold is one that is high, which requires that there be a clear and imminent danger that the privilege against self-incrimination would be circumvented. And the cases that have interpreted this particular principle have interpreted it to be narrowly applicable to just the applicant and not the applicant's father. Thus, opposing counsel's argument that implicating the father would run counter to the right against self-incrimination does not hold much water. Moreover, even if opposing counsel were to argue that the appellant's right against self-incrimination is in itself implicated, this does not stand as well, because the most crucial fact against the applicant's claim of imminent danger is that the Iridonian Public Prosecutor's Office explicitly refused to share evidence with FIFA. This shows that there's no ongoing collaboration between the two parties, and thus the applicant need not bother themselves with the fear that evidence that is collected within FIFA proceedings will be sent out to the public prosecutor. And I also note, Madam President had a question earlier on, is FIFA obligated to pass information that they find to the public prosecutor? And the short answer is no, because FIFA proceedings are confidential. This can be seen in Article 53, subsection 7 of the FDC. Now, finally, with regard to opposing counsel's argument regarding the right to occupation, taking this argument charitably, what it would mean is that I know that my time is about to elapse, members of the tribunal. If I could request for an extra minute to sum up this final argument. Okay,
Yep.
Thank you. Now, if we were to take this argument at its most charitable level, what opposing counsel means to say is that if the player's right to occupation was at risk when they had signed the agreement with FIFA, then the weight to be given to this particular article should be lower. Nevertheless, even if we were to take this into account, it still goes to show that under the CAST jurisprudence, which is what is relevant today, the right against self-incrimination has not been proven to exist. Thus, regardless of what weight we have to give to this particular article, the act of non-compliance is still something that is sanctionable, and it is one that would draw the consequence of adverse inference. This is supported by the IBA rules, Article 9, subsection 7, which states that the tribunal may draw inferences that are adverse to the defaulting party, should they refuse to produce any relevant evidence. I conclude my submissions.
Sorry, just one more question before you go, if you don't mind. What sorry, yes, okay. What is your position on whether your organization has overreached its position? Because it was very clear from the start that this has turned into a criminal investigation and has been overtaken by the state. Why is FIFA so interested in pursuing this case? And why is FIFA so interested in continuing this despite the fact that very, very competent bodies have taken over? Wouldn't it be much simpler to wait for a decision from the criminal courts and then make your disciplinary findings on that?
I understand that there are two questions within that, so I'll answer it in two parts. Firstly, with regard to why FIFA has chosen to even pursue this case, given the fact that there's already an ongoing criminal proceeding. Well, that's because the basis for this particular case and the principle for why FIFA has its own disciplinary proceedings is one that is far different compared to criminal proceedings in that state. Criminal proceedings tend to govern the behavior of members of that particular state for the safety of its members. And within FIFA as an organization, they have to take a particular stance against this, and they have to discipline this to ensure the integrity of sports and its own organization. Thus, both the Public Prosecutor's Office and FIFA have their own agendas in pursuing this particular case. And second, with regard to your question on why FIFA could not wait and see the outcome of the public prosecutor's case before moving forward. Well, the truthful answer is our client has not instructed us on why they have chosen this particular approach. However, if I were to hazard a guess, it would be that FIFA has already collected sufficient evidence to meet the comfortable satisfaction standard, because the standard that is required of evidence within sports disciplinary proceedings, both under the CAS and FIFA, is a standard of comfortable satisfaction, which is lower than the criminal standard of beyond a reasonable doubt. Thus, independent of whether the applicant is found guilty under criminal proceedings, they still may be liable to be found guilty under FIFA's own proceedings or even the CAS proceedings. With that, I pass my time on to my co-counsel.
Before I begin, can I confirm that members of the panel can hear me clearly?
Yep.
Good evening, members of the panel. As earlier introduced, my name is Seah, and I'll be addressing the further two issues on appeal by the respondent. Turning to the third issue, we submit that the anonymous witness statement and the email constitute admissible evidence as it meets the requisite conditions for admission under Article 6 of the ECHR. Thus, first establish the legal framework. We have to understand that this tribunal is seated in Switzerland, and as a result, the procedural validity of these proceedings is governed by Swiss law, specifically Articles 182 and 190, which...
I'm so sorry to...
Apologies?
Did you... Sorry, just to clarify, did you say that you were relying on these requirements under Article 6 of the ECHR?
Yes, so specifically Articles 182 and 190 of the Swiss Private International Law Act is read consistently together with Article 6 of the ECHR, as they both relate to the right to be heard and equal treatment. And directly
right, but I'm so sorry, but didn't your co-counsel make the submission earlier that the application of the ECHR is questionable?
Ms. Janie, in respect of that, actually my co-counsel made the submission that Article 6 is applicable, but the specific privilege against self-incrimination has not been met. While it could have been afforded in our case, the extremely high threshold of clear and imminent danger was not met. However, what we're addressing here is the admissibility of anonymous evidence in which Article 6 is indeed applicable, as I will demonstrate.
Sorry, just to press you on that a bit more. So how are we going to distinguish between what part of the ECHR we are going to use and what part that is going to be considered too high for us to use?
Certainly, CAS jurisprudence has outlined the specific threshold as noted in Jerome Velke and quoted in my co-counsel submission of the high threshold of clear and imminent danger, which applies to the privilege against self-incrimination. However, when it comes down to the idea of anonymous evidence, CAS jurisprudence, while interpreting Article 6 of the ECHR, noted that there are three factors to admit anonymous evidence, and this is the good reason for non-attendance. Secondly, the evidence must not be sole and decisive. Thirdly, there are counterbalancing factors that safeguard fair assessments of reliability. In both respects, there are very clear thresholds that need to be met for different issues to be addressed. And turning now to the three elements as I've noted, we submit that these elements are met by both the statement and the email. With regards to the first element, as interpreted in the 2019 case of Karim Karamuddin and FIFA, this panel does not require concrete threats or past violence. In fact, it assesses whether there's a real risk based on the context. And as earlier queried by Ms. Janie, she rightfully pointed out that there's a real chance or worry that the anonymous witness might have in terms of the threats. And in Karamuddin, this was precisely the case. as the case has accepted anonymity because the allegations went beyond spotting misconduct. And in that case, there was similarly criminal misconduct that was exercised by a powerful individual where witnesses were indeed vulnerable, and the same features feature in our case. Because this case involves alleged sports manipulation, alleged criminal networks, and substantial cryptocurrency transactions. And further, there was also an ongoing criminal investigation as confirmed by the public prosecutors under Exhibit 4 or Exhibit 5 of the record. And finally, in Paramount, the fact that a fellow witness was granted asylum on fear of reprisal gave objective third-party confirmation that the risk of reprisal was indeed real. And presently, while there are no conclusive proceedings, if I may then turn the panel's attention to page 36, para 2 of the press release. If the panel is listening, the fact that there exist parallel proceedings confirmed by state authorities is sufficient to prove objective confirmation that there's a real risk, although not a conclusive threat, which meets the threshold imposed by Article 6 of the ECHR. And with regard to this, and I note that counsel for the appellant had asserted that the witness had not been identified, but it was rightfully pointed out by Madam President that FIFA had indeed interviewed the person, so it doesn't mean that a witness statement was fake or created by somebody. In fact, FIFA actually met up with this person. So we submit that this really forms a base procedural safeguard. And turning now
Sorry,
to the
okay,
second
just on
element.
that point, I do understand that you're relying on the fact that FIFA has verified this account. However, I'm wondering if there's any safeguards against bias in that case, because clearly in this case, the witness testimony would be in FIFA's favor, right? So I'm wondering how we can trust the verification done by FIFA when FIFA has only produced one witness and it is in their favor. And in addition to that question, I have another question, which is that this witness, we are currently going off the basis that he is an honest, true witness with no bad intentions, and that is why we need to protect him against potential threats that would happen, right?
Yes.
But couldn't it also just be the case where this is an athlete who is trying to, I don't know, make use of the situation, do some politics and maneuvering, and maybe he has bad intentions where he wants to take over his teammate or something like that? How could we verify this as well?
Sorry, I'm gonna
Uh,
add on to that question, but even in light of all of that, even if we were to not, even if we were to admit the anonymous witness statement, my concern is more with the screenshot that was anonymous as well, because the anonymous witness statement by itself does not seem to tell me exactly whether the appellant was involved in match fixing, but it seems to be that the screenshot itself is more suggestive of the fact that his father was possibly receiving funds. But that is the one that we are unable to verify even on your end, right? Because FIFA didn't secure that screenshot. So after you answer my sister judge's questions, I would like to hear on this point. Yeah.
Certainly, members of the panel, I'll understand there are three main queries and I'll take them in turn. Firstly, regarding Ms. Janine's first question, we would argue that the nature of the witness statement itself already provides internal consistency. And the panel in Karamudin assessed whether the anonymous statements were coherent, whether they acknowledged their own limitations, and whether they avoided exaggeration. And this goes directly to Ms. Janine's question on whether we should be relying on such evidence. And in our case, the witness recounts a specific contemporaneous observation, a stress phone call the night before the match, while expressly acknowledging the limits of what he could hear or know. As in Karamudin, the witness also did not speculate about betting or criminal arrangements, but confines his account to what was personally observed, and it was similarly relied upon by the CAS jurisprudence. And this internal restraint is precisely what is a precise feature that CAS treats as a reliability indicator. And to answer Ms. Janine's second question in regards to the witness' true intentions, well, presently, we can look at the corroboration that's been afforded in our case. In if I may turn the panel's attention to PDF page 13, second paragraph under the title, Match Result Asia Handicap. The Genius report there identifies irrational betting, in-play movements, and market suspension. And furthermore, there's also an independent and financial criminal strength, including alleged cryptocurrency transfers and a prosecutor-confirmed investigation. And FK Poveda, the witness statement and email were considered not to be solely decisive, but is rather coherently corroborate independent objective evidence. And this witness statement itself does precisely that. And to answer Madam President's question regarding the anonymous screenshot, we will argue that anonymous screenshot similarly presents such evidence of corroboration, as it also clarifies that there is a possible cryptocurrency transaction, which was also noted to be possible by the Iridonian Public Prosecutors Authorities inside their press release. And furthermore, the FIFA authorities had also sent this document to the Iridonian Public Prosecutors, and based on that, they started their own criminal proceedings. So if a criminal authority, such as the Iridonian Public Prosecutors, can begin their investigations on such evidence, and notably in a criminal trial where the burden of proof is one of beyond reasonable doubt, it is arguable that in our case, which only merely requires the standard of comfortable satisfaction for such evidence to be relied on for our investigations. I note that my time is about to elapse. If I may have a minute to wrap up my last submission on the match manipulation claim. Thank you, members of the panel. Turning to the last issue, there are 4 factors that we have to establish to make out a claim of match manipulation. However, to first answer Ms. Janie's question, she rightfully pointed out that there was other evidence on the facts to go towards such a claim. And this is precisely the direction that the 2009 case of FK Poveda took, where they considered the overall picture / mosaic approach, when they noted that match manipulation is rarely proven by a single smoking gun, and the evidence that must be accessed must be noted together, and it must reach the comfortable satisfaction threshold. And turning now to the 4 factors to be met, firstly, we will argue that the act or omission attributable to the appellant has been met, as the Genius report highlighted specific below-level goalkeeping decisions. And if I may turn the panels to one such instance at PDF page 15, under the title Goals at 23-21, Fortuna attempts a lofted pass, and this passer is misjudged, and the comment left forward intercepts and rolls this into an empty net. This action itself satisfies the fact that decisions and moments in such a match directly shape match events, and under the Poveda mosaic approach, these on-field indicators do not need to prove intent alone. They are evaluated alongside betting and off-field evidence to reach the comfortable satisfaction. And that brings me directly to my second element, as to show whether there was conduct that affected or was directly affecting the match sporting reality. And turning now to the context of the match. The context of the match makes it highly consequential, where Iridonia only needed a point to reach the top group. And despite that, they lost 0-3 against Cometland. And the GS report concludes that the match may have been fixed after analyzing betting performance and patterns. And crucially, this betting report is not a mere decision or a mere subjective report by the GS report. Rather, it is objective based on on-field indicators and has been relied upon before in previous cases. Now, when we consider the mosaic approach, considering the fact that the appellant played poorly precisely when the market started showing a turn in Cometland's favor, this mosaic of evidence thus goes to show that there was indeed a conspiracy for match manipulation, which is a violation under Article 20 of the FDC. I know that my time is elapsed, and if I may have further assistance. Yeah.
Counsel, in the report that you are citing, aren't you conveniently leaving out the facts that there were other teammates of Iridonia that also say messed up? I mean, there was a few. I mean, there were a few other instances that I can see in which they didn't do as well, or they played poorly. So could we really say that Fortuna is the main reason for uh Iridonia's loss. And following up on that, I mean, Fortuna did explain that this was because he was feeling unwell. So are we how sure sorry, I mean, what do you say about the fact that I mean he has admitted or he has explained that he was feeling unwell, and how does that line up with your argument that he did it on purpose, that he was match fixing in light of all of these other facts?
Certainly, Madam President, to address your first query, if I may then turn you to the most damning evidence in our case, is that the night before the match, which is approximately 12 hours before the match started, the anonymous statement detailed the phone call where the appellant looked stressed before his father. And I believe that this was what the counsel for the appellant had relied upon, and this can be found at Exhibit 2 at paragraph 9, if the panel is with me.
I understand, but counsel, that what I don't understand about this anonymous witness statement is why the fact that Mr. Antonio Fortuna was supposedly fighting with his father is directly related to the match fixing. I mean, family members, we surely there are instances of disagreement that not necessarily have to be linked to this match, right?
Certainly, Madam President, but however, if we don't consider that fact alone, it can be true that he was just simply having maybe a fight with his father. However, if I may now turn the panel's attention to page 12 of the PDF, under the Genius report titled Match Results / Asian Handicaps, and to keep in mind of the 12-hour timeline that was previously noted by me, the betting support at that moment, at the 12-hour juncture, began to pick up pace. Where the betting support, I mean betting support for Comet Land, despite Iridiona being the clear favourites. So if we do correlate the fact that right after the phone call, such betting support started to take place, the nature of the phone call may be inferred to deal with the possible match manipulation claims. So understandably, Madam President did note that if we look at the evidence alone, it could be interpreted in many different ways. But if we look at the FK Pobeda approach relating to match manipulation claims, when we look at strands of evidence that ties together, such as this coincidence, it can be said that there is a clear evidence of match manipulation in this respect. And to answer Madam President's second question as to whether Mr. Fortuna was feeling unwell, right at the score of 3-0, if I may turn the panel's attention to the 82:43 moment located at PDF page 16, under passages of interest. At the very last moment, the goal was well saved by the goalkeeper Fortuna, despite being pressured so much by Comet Land. And to consider that it was the 82nd minute, and if he was truly sick, he would have been fatigued and sick all the way to the end of the match, and yet towards the end, he is still able to play so well. So even if we consider that he was sick, we will argue that it should not be given any weight, given that he was able to sustain his performance throughout. And to add on a further strand of evidence, it is not simply the fact that the goalkeeper was substituted only for this match. If I may turn the panel's attention to paragraph 2 of the record, right at the first page, it is noted that he had built a solid reputation over the past 2 seasons. Therefore, he wasn't simply playing this first match as a first-time goalkeeper. Rather, he has had a sustained good reputation over the past 2 seasons for him to even take over the current goalkeeper who was injured. And therefore, we will submit that his performance should be considered in light of the timeline.
But counsel, isn't it even more so that because he had a solid reputation the past 2 seasons and that he performed poorly for this particular season for this particular match where he explained that he was sick, doesn't that line up? Like, doesn't that corroborate that he was perhaps indeed sick?
And also, what is FIFA's ability to pass judgment on athletes' performances? Because I'm thinking, what if this is really a bad day for him? I mean, athletes are human, athletes are under incredible amounts of pressure. Maybe this guy really just had a bad day and couldn't perform. Everyone cracks under pressure. And even notwithstanding that, right, just on pure principle alone, how can we allow FIFA to pass a judgment on whether an athlete is performing to their usual standards or not? because I mean FIFA is not athletes. We do not have experts present here, and we can't possibly make that judgment with the expertise needed for every single sport.
I understand. If I may address Madam President's question first on whether the panel was indeed sick. Now, as earlier introduced, the mosaic framework under FK Pobeda, if we do consider that the panel was sick and that he did play poorly as an individual strand of evidence, yes, we do understand that the interpretation can go multiple ways. However, their concrete on-field acts by the appellant flagged as below expected in critical moments, and there's strong objective betting market intelligence indicating that the match or outcome was targeted and bookmakers did indeed have to intervene to close the markets. Therefore, when we consider this whole strand and this whole specific fact pattern together, a claim under match manipulation could be possibly made out, and it will be argued that it will meet the threshold of comfortable satisfaction. And to answer Ms. Janine's question regarding the ability to pass performance, CAS president, specifically FK Pobeda and Oryakov, had also relied on such objective betting reports and a performance analysis, although not by Genius, but similar companies, to determine if a match manipulation claim can indeed be found. As notably, there are not many other strands of evidence that can be used to identify match manipulation and is considered to be one of the more prominent offenses these days. However, these betting reports help to provide objective analysis by third parties, not FIFA itself, and FIFA bases its decisions on the third parties. Therefore, it is not a pure assertion that FIFA is making that the appellant was indeed liable for match manipulation, but rather taking into account objective third-party evidence to make such a claim. And unless I may be of further assistance on the last issue.
I actually have two more questions that are slightly unrelated to what we were discussing. But
Certainly.
Rachel, do you have any other questions for this point?
You can go ahead first.
Okay. So my first question is that if your argument is based on the mosaic approach, doesn't that mean that if we don't admit the evidence, your case falls?
I know that Madam President, Ms. Janie has a second question as well. Or would you prefer me to?
Yeah, I can ask the second if as
Okay.
well. The
Yeah.
second question is, I'm wondering, are you placing any weight on the lower court's finding that he was guilty of match fixing in your arguments?
To answer your question in two parts, we do not agree with the assertion that not admitting a specific evidence would tear apart this mosaic, as notably a mosaic is filled with multiple strands of evidence. And in our case, we're not relying solely on the performance analysis. However, we are considering the betting reports, the anonymous witness statement, the anonymous WhatsApp messages to help form this mosaic to find that the appellant was indeed liable for match fixing. So therefore, even if a single strand of evidence is not accepted by the CAS jurisprudence, we will argue that other evidence here does help meet the threshold of comfortable satisfaction. And to answer Ms. Janie's second question on the weight that we can afford to lower courts proceedings, CAS is able to conduct a de novo hearing to identify the merits of the case. Therefore, it is not bound by the findings of the lower court. Rather, they can evaluate the merits of the case themselves based on the evidence that we presented to them today. And unless I may be of further assistance to either of the judges.
If I could just push you on one more point. This
Certainly.
goes back to my question about how it seems like the other teammates of Iridonia messed up as well. I don't think I heard an address on this point. I mean, Santiago, Royce, and Paul, from what I see, also made errors in judgments that led to Cometland being able to score. And in fact, I think in the ending of the match, you also mentioned that Fortuna managed to save a goal being made by Cometland. So how does this how does this fit into your arguments in saying that Fortuna is the main guy who is is the main guy that you are accusing of match fixing, and why is it not that the entire team as a whole is involved in this if we are talking about their poor performance being um evidence of the match fixing. And
So,
if Fortuna had saved the goal from being made, doesn't that also go towards showing that he didn't want them to lose entirely? Yeah.
certainly, Madam President, I'll answer the question in three parts. Firstly, we have to consider Mr. Fortuna's position, which is of a goalkeeper. And notably, his position of a goalkeeper is the most, we will argue that it's the most susceptible for goal-making opportunities, and that will give him more opportunities to manipulate the match. And secondly,
Sorry, we
if
could argue that point actually. Are you really so sure that the goalkeeper is the make or break in this situation? Because arguably, if the team never let it get that close to the goal in the first place, they wouldn't even have an opportunity to score. So how can we say that it was just the goalkeeper when, maybe they just had a crap defense that day?
certainly, certainly, Ms. Janie. And to answer both the members of the panel's question, if we just simply look at the performance analysis and the passages of interest itself, the respondent's name, Mr. Fortuna, occurs at almost every single juncture with relation to passages of interest or whether he was in some way, shape, or form related to whether a goal was made. So if we consider the fact that his name was included in high such frequency in the report itself, it could be argued that the objective third party looking at the facts of the match realized that he was either instrumental or maybe not instrumental in some of the goals that were scored or passages of interest. And the high frequency of his name, we will argue, directly coincide with his ability to manipulate the match. And therefore, his actions were flagged out directly as to a reason for why such goals were being made. Members of the panel, I note that my time has elapsed. If I may be of further assistance.
Nope, that's okay. Thank you.
Thank you, members of the panel. I'll now hand over my time to the appellant for rebuttal.
Madam President and Ms. Arbitrator, just 2 points in rebuttal. The respondent relies on the betting report and the anonymous witness statements. That they are admissible. We argue this is incorrect. The evidence is strictly double hearsay. It is an anonymous witness who has not been cross-examined and who has refused to audio testify. And merely still, it is only rumors that the father was engaged in allegations with a criminal organization. And on the second point, I noticed Ms. Arbitrator queried about the performance of the other teammates. And we say that this is correct. There may be other players in the match who have bad intentions. For example, Santiago, who attempted a backwards goal only to be saved by Mr. Antonio Fortuna himself. And lastly, the cast panel has held that anonymous witness statements is not admissible if they are not verified by the court and if they do not get an opportunity, if there is no opportunity for cross-examination. This concludes my rebuttal. If there is no further questions, I will hand the time back to respondents.
Members of the panel, 2 points in rebuttal. Earlier, counsel for the appellant had asserted that nowhere in the facts that the appellant chose not to testify. However, there's nowhere in the that the appellant had chose not to testify. However, nowhere on the facts did demonstrate that. And we have to consider the position of the witness in our case. If he chooses simply not to testify or not even give a statement, or if he's forced to go into court to give such a statement, he may not even be able or willing to provide evidence in today's investigation. Therefore, we have to consider the wishes of the anonymous witness when we consider whether we should be accepting his evidence. And secondly, counsel for the appellant has also asserted that we have to consider the actions of other players. However, we have to consider the lack of other overwhelming evidence. Looking past the performance of the appellant himself, we have to consider the anonymous witness statement, anonymous WhatsApp message, the backing reports. Looking at all of these strands of evidence, combined together with the fact that the appellant chose to play poorly right at the juncture where the market started to close, that would have benefited the conspiracy greatly, it goes to show that there can be a claim of match manipulation made out without solely looking at the performance of the appellant himself. And unless I may be of further assistance to the panel, this concludes my submissions. Thank you.
Thank you.
Just, yeah, we can stop.
I'll stop the recording. Okay.